the questions of law, which I wanted to address, almost all has been substantially covered by the learned Solicitor General. He has effectively at length dealt with each of the issues. If Lordships are to kindly see the written note, almost all the questions.
I only want one thing.
Yes.
All of you have argued many things.
Yes.
What is the role of the Chief Minister? Nobody has said.
In this matter,
Yes.
yes.
It is his sanction.
Correct.
Something should be answered that, but towards
Yes.
that also.
Certainly.
Nothing to answer.
Nothing to answer?
Well, there's nothing. That's why.
We will justify that. The role of the Chief Minister shall.
All right.
Yes. But if Lordships are to see Roman numeral 1, the questions which we have framed in the written note which has been given.
And is he telling this post lunch? Yes. Yes.
Please. The course of action, the competent authority, that is the Honorable Governor, was to adopt.
No, I'm only on 17A.
Yes.
17A says
It is 17A.
recommendation, decision taken.
True.
This,
True.
that's all I'm.
I'll cover that issue as
Yes,
well.
yes.
Lordships may kindly permit me to read these questions. But for in all probabilities, I may not repeat what the Solicitor General has already
yes.
done.
Yes.
Maybe a couple of inputs from the own perspective, I'll just put it across. Kindly see the questions, but I'll just quickly read it out so that Lordships will know what are the issues involved. The first question is about the course of action the Governor must take when he receives a complaint against the Chief Minister. Then the question they have raised about the aid and advice, whether he is expected to consider the same. Then about the issuance of notice to the public servant concerned. Third one is about non-application of mind. And whether the fourth one is whether it could have been at the instance of the police officer concerned alone, or whether a private citizen also could have initiated these proceedings. But on the question of aid and advice, Lordships themselves remarked during the course of the hearing that they are having decisions.
No, aid and advice.
To that effect. Not only one aspect I just wanted to highlight. But in fact, MP Special Police Establishment case was not a case of the Chief Minister. It was a case of former ministers, wherein R.S. Nayak versus A.R. Antule was cited.
Yes.
It is the first of the decision, the R.S. Nayak versus A.R. Antule. The question was, where interestingly, the learned Advocate General had conceded before the Bombay High Court that aid and advice is not required.
That's at paragraph 10 of the 1992.
Then their Lordship said that concession was rightly made. And they thereon gone to say, this is what the word I wanted to emphasize. There is no doubt that there is a conflict of interest in the Council of Ministers. Therefore, two situations arise. One is the Council of Ministers can say, we disable ourselves from giving an advice in this matter to the Governor on account of the fact that there is likelihood of a conflict of interest. This is what the Honorable Supreme Court says. There are two scenarios. Either when the Council of Ministers disable themselves, the second one is interesting. They use the word, they become disentitled to aid and advise the government. But may I just emphasize Lordships on that particular word they use there? In the
that's paragraph 10 of the judgment.
Yes, but I am referring to MP Special Police Establishment where they extract R.S. Nayak. May I request Lordships to kindly see para 23. What's in that? But this is in the petitioner's compilation of judgments at page 258.
Yes, sir.
Please. The word apparent bias versus a likelihood of a bias has been emphasized after quoting R.S. Nayak at para 13, Lordships may kindly peruse that.
Yes.
Mr.
And that-
Sorabji also points out, Lord, that is the, it commences from that sentence.
Yes, sir.
Now, Lord, may I request Lordships to kindly see the next page at page 261.
261.
261 of that compilation, but I'm sorry.
Well, I am holding your compilation here.
We have also given MP special policy.
If you're
Then-
citing MP special
Yes,
establishment.
yes, Lord, that's.
That's paragraph
Lordships may
19
kindly
next.
see then paragraph,
19.
please. Paragraph 13,
13, yes, first.
please.
Next 19.
In 13, Lords, just one sentence I want to
Yes.
emphasize. Lordships get that the statement,
Yes.
para 11, Lord, extract of R.S. Nayak in MP, para 11. The question then is whether we should permit the state of Maharashtra to resile from the concession made before the High Court and raise before us the contention now advanced by the learned Attorney General. We have not the slightest doubt that the cause of justice would in no way be advanced by permitting the state of Maharashtra to now resile from the concession and agitate the question posed by the learned Attorney General. On the other hand, we are satisfied, lots of get that,
Yes.
that the concession was made to advance the cause of justice, as it was rightly thought that in deciding to sanction or not to sanction the prosecution, but this is the telling statement by the Honorable Supreme Court, not to sanction the prosecution of a chief minister, the governor would act in the exercise of his discretion and not with the aid and advice of the Council of Ministers. The application for grant of special leave is therefore dismissed. Then, Lord, Lordships may kindly see paragraph 23,
24, 26.
23, Lord, may I? 23, Mr. Tanka
Yes.
is not right when he submits that the governor would be sitting in appeal over the decision of the Council of Ministers. However, as stated above, unless a situation arises as a result whereof the Council of Ministers disables or disentitles itself, the governor in such matters may not have any role to play. Taking a cue from Antule, it is possible to contend that a Council of Ministers may not take a fair and impartial decision when the Chief Minister or other members of the Council face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under statute in relation to former ministers. That is the distinction what they have made about former ministers, chief ministers, and sitting ministers.
Ultimately, 33 is what is important.
Yes. Therefore, they hold, of course, not there. They found the persons, Mullards, against whom this sanction was what had by that time ceased to be the ministers. And the cabinet did not have them as part of the decision. Therefore, they said that the theory of apparent bias will not apply. Likelihood of a bias is likely to be, but then
A reasonable
they
man's
found that
theory.
it was
What
not
the reasonable
applicable.
man would think. That's the theory.
My submission, limited submission before your lordships, therefore is the Council of Ministers, by virtue of the fact that they become interested in the matter, disentitle themselves from any aid and advice to the Council of Ministers. But quickly about the Honorable Chief Minister remaining outside the meeting, therefore, the Deputy Chief Minister presiding over them, I must say that very judgment, interestingly, they quote A.K. Kraipak. But A.K. Kraipak, lordships are aware that Nashband, interestingly, was the chairman of the selection board and had also participated in the selection process.
Apparent bias.
There, my lord, interestingly, Nashband did not participate in the proceedings. May I just request lordships to kindly see the same judgment once again. MP Special Police Establishment, their lordships note this and say still the theory of apparent bias will continue to apply. That Nashband's act, lords. Lords, at para 16. This is para 16, they extract para 15.
Yes.
But their lordships, the sentence commencing from, it is true that ordinarily the chief conservator of all that lordships may not refer to. Kindly see from the word. But under the circumstances, it was improper to have included Nakshban as a member of the selection body. He was one of the persons to be considered for selection. It is against all canons of justice to make a man judge his own cause. It is true, lordships may kindly note, it is true that he did not participate in the deliberations of the committee when his name was considered. But then the very fact that he was a member of the selection board must have had its own impact on the decision of the selection.
Yes, the words, his bias is likely to operate in a subtle manner.
And therefore, the presence of the chief minister in this case and there must be felt an omnipresent presence, brooding presence, we say, in the hall, wherever this meeting took place. But on this question, lordships will also kindly see Article 163 does not bifurcate between Council of Ministers and the Chief Minister. Article 163, in fact, says there shall be a Council of Ministers headed by the Chief Minister. And in the theory of collective responsibility, etc., lordships are aware of those. The question of Chief Minister bifurcating himself from the decision of the Council of Ministers does not arise. Therefore, looking at this aspect, the question of the governor consulting or looking into the aid and advice of the Council of Ministers does not arise. But on the question of the second aspect, lordships will kindly see about principles of natural justice, 17A.
Yes, sir.
But there is, of course, before I advert to this, they have cited several judgments, including Shamsher Singh, R.A. Mehta, to say that governor cannot act in his individual discretion, etc., including Nabam Rebi. Of course, all these decisions which their lordships have laid down were in different contexts. For instance, in Shamsher Singh's case, subordinate judicial officer was dismissed by the minister concerned without reference to the governor. They were asked to reconsider Sardari Lal's case, where for the first time Sardari Lal's case held satisfaction of the president or the governor means the governor himself and not that of the Council of Ministers. Therefore, authoritatively they held satisfaction of the president under Article 74 or of the governor under Article 163 must be construed in a democratic polity like ours is to be that of the satisfaction of the Council of Ministers. Therefore, the principles of Shamsher Singh was different. In R.A. Mehta's case, the appointment of Lokayukta was in interpretation of the Gujarat Lokayukta Act, where the Chief Minister's primacy is there. Of course, now the law stands settled from a decision arising from this honorable court, Justice Chandrasekhar versus Siddaramaiah, where their lordship said it is the primacy of the opinion of the Chief Minister which will prevail. Third decision, these are the three decisions which they have cited, is Nabam Rebiya. There again, Article 174. The power of the governor to call for a session prorogate. And in the factual situation of that, they said that no, it could not have been done in individual discretion. Two decisions of the Honorable Supreme Court, similar fact situation as to when the Chief Minister's complaint or allegation against the Chief Minister comes, the governor is bound to act independently. Therefore, the decisions may have to be discerned, distinguished in this manner. But on the question of 17A, 17A on a plain reading does not contemplate a notice to the public servant concerned. But whether we can read into that as an opportunity to be given to the public servant concerned before the competent authority arrives at a decision. But I would request lordships to kindly permit me to refer to Subramaniam Swamy versus Director CBI.
Hmm.
So it is not that these provisions like 17A or novel. Lordships are aware in number of enactments, lords, permission to investigate a threshold bar is always there. One of them was Section 6C of the Delhi Special Police Establishment Act, which their lordships, in this Subramaniam Swamy's case, struck down. But one of the arguments advanced by Mr. Anil Diwan in that matter, lords, I propose to draw that, wherein he says, if you allow this notice to be given to the public servants, etc., concerned at this stage, it would certainly leave the situation for tampering of evidence, etc. Now, may I request lordships to kindly see that judgment? Yes, Subramaniam Swamy.
Para 14. Sir.
Yes, para 14. I'll read for my satisfaction. That, of course, I must bring to lordships' notice that paragraph, though he advanced that argument, their lordships, of course, struck it down on the ground of Article 14. You can't
It was on a different.
bifurcate corrupt officers into joint secretary and above and below. Their lordships held it in that manner. Para 14, I'll just read.
Yes.
Anil B. Diwan, learned amicus curiae, wants us to take judicial notice of the fact that the high-level bureaucratic corruption goes hand in hand on many occasions with political corruption at the highest level. This very group of high-ranking bureaucrats whose misconduct and criminality, if any, requires to be first inquired into and thereafter investigated, can thwart, defeat, and impair this exercise. In substance, the potential accused would decide whether or not their conduct should be inquired into. He argues the essence of skillful and effective police investigation is by collection of evidence and materials secretly without leakage to the destruction or tampering of evidence and witnesses. Such investigation is compromised by the impugned provisions, namely Section 6A of the DSP Act. The next sentence. The requirement of previous approval in the impugned provision would mean leakages as well as breach of confidentiality and would be wholly destructive of an efficient investigation.
Yes.
Therefore, Lord, if the argument of the other side is to be accepted, let us take a case where there is an allegation that a document has been forged by the public servant concerned, or any number of illustrations could be given. And the police officer who receives this credible information, or a private citizen who comes to know of it, goes to the competent authority and says, sir, I have come to know about a particular delinquency of a public servant concerned. I want immediate investigation to be initiated. Maybe he be apprehended, search be conducted, these material objects be, the incriminating material be seized. Would stand defeated, my lords, if notice is to be given to the delinquent employee or the public servant concerned. But this is one way of looking at it. And I draw the argument of Mr. Diwan when he argued the DSP Act for the purposes to say that 17A expressly, consciously excludes notice. One more perspective about this would be, lordships are aware, these 17A and 19 came to be amended, but in 2018. For the first time in 2018, when a private citizen files a complaint under Section 19, notice to the public servant is contemplated. Lordships have seen that 19. Lordships are aware that when a private citizen comes to him, the steps are that he goes before the magistrate. Magistrate finds some prima facie case, refers him to go to the competent authority to obtain sanction. He goes back to the competent authority, and then competent authority is obliged to issue notice to the public servant concerned. That is the provision. But the submission which I propose to make before your lordships is, in one stroke, in one legislation, if the legislature has thought it fit to prescribe two different procedures in respect of sanction. One is, of course, a sanction, another is a pre-approval. In respect of sanction by a private citizen, it says that notice is required. In the same amendment, when they introduce 17A, the concept of notice is very conspicuously, consciously silent. The construction of a statute, according to me, therefore, it cannot be stretched to say that the legislature was not aware that when 19 we provided a opportunity to be heard, 17 we do not provide.
19 operates in a different circumstance.
But all the time.
Post
please.
investigation.
No, all the time. No, all the time I am submitting before your lordship. The concept of hearing. The concept of hearing is afforded in 19. 17A it is not done so very consciously. In fact, I am submitting when the legislature by the same amendment provides two different procedures. Therefore, this aspect that the prior opportunity should have been given does not merit. But there are three judgments. One, of course, the learned Solicitor General has read. That is that is, lordships will kindly, only one judgment I want to refer to on the question of principles of natural justice in criminal proceedings. That Devanand Singh versus State
Devendra Singh.
Devendra Singh versus State
Devendra Nath Singh.
That's the first one, Devendra. May I request lordships to kindly see that page 52.
Para 52.
No, para 52, not page 79.
Yes. What is audio alterum partem in criminal laws?
Lordships get that. Para 50.
Yes, Chadda's case is quoted.
Yes, Vin Chadda's case.
Vin Chadda's case
Yes,
is quoted. Principles of audio alterum partem as held in Vin Chadda is accepted and said.
They said, therefore, that paragraph, I
Yes.
just wanted to bring to lordship's notice this paragraph. Where they quote Vin Chadda, saying, for the present purpose, this is the declaration by their
Yes.
lordships there.
Yes.
Suffice it to notice that as regards the process and manner of investigation, which included the issue relating to the letter report, the court inter alia pointed out that the exclusion of the principle of audio alterum partem in relation to an accused at the stage of investigation is the following. I will not that para 81.
So there, the apex court holds the earlier persons were not investigated into. When you want them to come to investigation later, at
True.
a later stage, you should have given them an opportunity, but not in all cases.
In all
what
cases,
is-
one of the arguments they said that different stages the police should have.
Their circumstance was different.
No, but they they import this concept of audio alterum partem and say that in all cases,
Yes.
this principle straitjacket formula cannot be used as a straitjacket formula. Is all that.
See para 53, next para.
Please.
In fact, it was said that opportunity ought to have been given.
In the peculiar circumstances.
That's what.
That's
Peculiar
that's correct.
circumstances.
Where investigation was being ordered against persons
Yes,
who were not investigated.
investigated.
That's correct. 173 subsection 8, the further inquiry. But Subramaniam Swami, both the learned Solicitor
They've
General
already-
and
they've already relied on.
Mr. Maninder Singh, para 44, only one sentence of that 44 words, interpreting the same argument there. Whatever the argument which was advanced by Ranet's friend, 19 unamended stood silent on the question of opportunity. They said opportunity should be given. But even at post-investigation, they said no, it's not possible. They also say that it is the matter of sanction is administrative in nature. It is not quasi-judicial. That is one principle. Second principle is question of notice does not arise. So they refuse to read into the principles of natural justice in the unamended 19. It's exactly the argument today before your lordships. Therefore, the concept of issuance of notice does not arise at all, and it would in fact cause prejudice to the sanctity of investigation is my respectful submission to lords.
Yes.
The last limb of this would be whether the public servant concerned at the stage of 17A will have any enforceable right. Or the right of hearing, my lord, would depend on the kind of right which subsists in any provision. My lord, my submission before your lordships is, when a complaint or an allegation comes before the competent authority seeking permission to investigate, there is no right, my lord, as such vested with the public servant at that stage.
Yes.
There is no right vested with the public servant at that stage. In fact, my lord, he is a person who cannot participate in the proceedings at all. It is for the competent authority to decide whether, my lord's, permission should be given or not. Even at the next stage, if assuming, my lord, the matter is to go before the station house officer for registration of a cognizable offence, even there he does not have a role until, my lords, a first information report is lodged and he is shown as an accused, but which the Honorable Supreme Court in number of decisions says, if a first information report is registered by a station house officer where no cognizable offence is made out on the basis of the averments which are available, he gets a right to move your lordships under 482, etc. So the right to an accused, when he is made an accused, at that stage commences. At the stage when 17A is invoked, not, he does not have any right. Therefore, the question of hearing does not arise, is what I would submit. But the third lord's limb would question would be as to whether the order of the governor, lords, stands vitiated on account of non-application of mind. That has been argued at length. Learned Solicitor General, lords, has shown before your lordship the original papers itself. I have had the benefit of hearing, though I did not have the access to the records. But what we could make out is elaborate consideration has been made by the governor, and my lord, to reach to the conclusion that pre-approval is required. Only two aspects from the order of the governor I propose to, my lords, highlight before you. Two developments which the honorable governor takes into account is two orders passed by the government themselves. One is the order, my lord, constituting a 4-member committee headed by one Shri Venkatachalapati for investigating into the matter. Second is, my lords, the constitution of a single judge commission of inquiry.
P.N.
Under the
Desai.
commission of inquiry
Justice
Act,
P.N. Desai.
for the purposes of looking into this matter. But may I now request lordships to kindly see the terms of reference and the nature of the order while constituting these two orders. They have produced it along with the writ petition. My lords may kindly see volume 2 of the writ petition at page 591.
$592.
591 is that first Venkatachalapati report.
Yes.
At 592, my lords, when they say 1/7/2020 for other kin ಮೇಲ್ಗಡೆ paragraph.
All right.
May I just read that paragraph? ವಿಶ್ವವಾಣಿ ಪತ್ರಿಕೆ ವರದಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆಯಲ್ಲಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ನಿವೇಶನ ಹಂಚುವ ಮೂಲಕ ಹಗರಣ ನಡೆದಿರುವುದು, ಇದರಿಂದ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅಪಾರ ನಷ್ಟ ಉಂಟಾಗಿರುವುದು, ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗಳಿಂದ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ಬರುತ್ತಿರುವ ಅನೇಕ ದೂರುಗಳಿಂದ ನಿಯಮ ಬಾಹಿರ ಕ್ರಮ ವಹಿಸಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತಿದೆ. ಇದರ ಸತ್ಯ ಅಸತ್ಯವನ್ನು ಅರಿಯಲು ಒಂದು ತನಿಖಾ ತಂಡವನ್ನು ನೇಮಿಸುವುದು ಸೂಕ್ತವೆಂದು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಕೇಳ್ಕೊಂಡು now lordships may kindly see the terms of reference to the under the Commission of Inquiry Act at page 594. Almost, lords, there are about 7-8 questions they have framed. Almost every question refers to illegality of allotment of sites, illegality of the method and manner in which MODA acted in giving these sites, including as to whether persons had benefited themselves, though they were not entitled to so. But may I request lordships to kindly see terms of reference 6, 7, and 8. ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಪರಿಹಾರದ ರೂಪದಲ್ಲಿ ನಿವೇಶನ ಜಮೀನನ್ನು ನೀಡಿದ್ದಲ್ಲಿ ಅದನ್ನು ಗುರುತಿಸಿ ಸೂಕ್ತವಾದ ಕ್ರಮವನ್ನು ಜರುಗಿಸಲು ಸಲಹೆಯನ್ನು ನೀಡುವುದು. 7. ಕಾನೂನಿನಲ್ಲಿ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗಳೆಂದಾದ ಮೂಡಾ ಸಂಸ್ಥೆಯು ವಶಪಡಿಸಿಕೊಂಡ ಜಮೀನುಗಳ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಹಾರದ ಬದಲಾಗಿ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲು ಮೂಡಾ ಸಂಸ್ಥೆಯ ವಿವಿಧ ನಿರ್ಣಯಗಳನ್ನು ಕಾನೂನುಬದ್ಧವಾಗಿದೆಯೋ ಮತ್ತು ಬಂಧನಕಾರವಾಗಿದೆಯೋ ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಹಂಚಿಕೆ ಮಾಡುವ ಸಿಎ ನಿವೇಶನಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಡೆದಿರುವ ಅಕ್ರಮಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸುತ್ತೇವೆ. ಅಂಡ್ ಇನ್ ದ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ದೇ ದೆಮ್ಸೆಲ್ಫ್ ಸೇ ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿದೆ ಅಂತ. Prima facie, there is illegality insofar as the entire, let's say, I would not say scam, but entire allegations which have been made. And these are the present complaint on which the governor acted upon, or what was before him, Lords, was the same one. But the governor therefore records, if the government is satisfied that the allegations require an investigation, albeit by a retired judge under the Commission of Inquiry Act and by a committee of IAS officers, the principal, then he takes it slightly higher. He says, when a person is accused or there is an allegation against him, the investigations shall not be at his instance or by his choice. This is one of the reasoning the Honorable Governor takes. Therefore, he uses the word non-partisan investigation is required into the matter, and these Commission of Inquiry etc. do not inspire confidence. This is how, Lords, my respectful submission to Lordships would be that when these considerations are taken into account, apart from the elaborate notings which they have submitted before your Lordships, it cannot be said that there is non-application of it. No, it is one thing to say the governor should not have acted in this manner or not, but it cannot be said that there is non-application of the mind. But he has applied his mind. He has perused these orders and seen that there is a requirement of an investigation even according to the government. Lord, then about the difference between approval and sanction. Sri Rupa, the learned Solicitor General, has read their paragraph in that written note itself.
Yes.
I've given at page 5, para 34, 35, 36, 37.
Yes.
But there is one decision of the Delhi High Court on this
17A.
17A. That in that compilation itself, Lordships. AP Patak versus CBI. That is at page 167 onwards. But there, para 9, 10, 11. They were, but this is, I'm sorry, but this is about 6A of the Delhi Special Police Establishment Act. That question of consent, similar situation. That consent, before investigation. Para 9, Lordships mechanics.
Yes.
In Mayavati, Honorable Supreme Court was dealing with the case of consent from the state government for the registration of FIR and to investigate the matter. In the absence of which the CBI had no jurisdiction to register the FIR.
No, there is consent under the Delhi Special Police.
They have interchangeably used the word. Kindly see para 10. There is an obvious distinction between approval, consent, and sanction. Therefore, they club approval and consent as one category and sanction of the other. An approval or consent implies mere concurrence or agreement, whereas sanction confers an authority on the person in whose favor power to grant sanctions conferred. The difference between approval, consent, and sanction is that of a degree in state of Maharashtra versus Janardhan Ramachandran Navalkar. Their Lordships have examined that, and kindly permit me to read that paragraph, where they refer to Prevention of Food Adulteration Act, similar provision for consent. Besides, it must be remembered that under Section 20 of the Prevention of Food Adulteration Act only, consent of the commissioner is necessary and not sanction. There is obvious difference between consent and sanction. consent implies mere concurrence or agreement, whereas sanction confers authority on the person in whose favor sanction is granted. Therefore, considerations applicable in the case of sanction would, in my opinion, not be applicable to case where mere consent is required. Therefore, this is what in Sri Rupa's case, what the coordinate bench says, it is much narrower. The approval has to be very brief. And as the Solicitor General rightly put it across, particularly when it is being exercised by possibly the highest constitutional authority. He does not want to prejudge the entire issue so that it would influence the investigating authority, whatever it is. That is the difference I wanted to bring to Lordship's notice between 19 and 17A. As regards as to whether 17A could be at the instance of the police officer concerned alone, Lordship's decision in Ashoka versus State of Karnataka, in fact, takes that into consideration. Para 534, Lordships are aware of that, where Lordships, in fact, considered this aspect and held that if a private citizen wants to move the court, he has to obtain pre-approval, necessarily implying that he can also move 17A before the competent authority. Then Lord Subramaniam Swami's case relies upon that. Just two or three aspects I wanted to bring to Lordships. One of the arguments which was advanced before your Lordships is that the order of the governor must be tested on witness principles, etc. Just like any other administrative order. And therefore, if it is found that he did not address himself to the questions which really arose, it must be struck down. That was the line of the argument. But I was wondering whether when a governor passes an order, but notwithstanding the fact that he's answerable, in a way not answerable to the court, but if an order of his is impugned before your Lordship, what should be the approach of judicial review? But one sentence in Bommai's case, though my lord, their Lordships were examining decision under Article 356, maybe my lord throw some light. May I request Lordships to kindly see Bommai, my lord, they have cited at, I'll just bring
Where is
Lordships. They have cited Bommai at Lords at page 310. But I am very conscious when I read this that this was a case where 356.
Article 356.
But not kindly look at the way their Lordships describe the role of the governor when he exercises his power under the Constitution. Article 163, Madam, page 639.
We go to para 282.
But I am referring to para 373 first. Lordships get para 373.
Yes.
In 373, if my lords are to see the sentence commencing from, this is not true of our Constitution, it says.
Yes.
Lordships get, this is not true of our, para 370. Same copy. But 373 commences from the sentence whenever proclamation.
Yes.
They are not there somewhere in the middle. Lordships get that government of Malaysia, they refer to 58(2).
Yes.
Then the sentence commencing from that is not true of our Constitution.
Yes.
That is not true of our Constitution. Hence, the President acts on the aid and advice of the Union Council of Ministers and not in his personal capacity. Moreover, there is a check of approval by Parliament which contains members from that state against the government legislative assembly of which state action is taken as well. So far as the approach adopted by this court in barium chemicals is concerned, that is not classical administrative order, how to test. That's how they'd argue. But kindly, it is a decision concerning subjective satisfaction of an authority created by a statute. The principles evolved then cannot ipso facto be extended to the exercise of a constitutional power under Article 356. Next sentence is what I would request lordships to kindly consider. Having regard to the fact that this is a high constitutional power exercised by the highest constitutional functionary of the nation. Obviously, they were referring to the president.
There the
It
president.
may not be appropriate to adopt the tests applicable in the case of action taken by statutory or administrative authorities, nor at any rate in their entirety. We would rather adopt the formulation evolved by this court in state of Rajasthan, as we shall presently elaborate. Therefore, my lords, having regard to the fact that the order comes from the governor, who, my lord, under the scheme of the constitution, is the highest constitutional authority. The principles of judicial review sometimes, my lords, may have to vary, is my submission before your lordships, insofar that is concerned. But since I am referring to Bommai, my lord, I would also request lordships to kindly see paragraph
320.
paragraph 3. Lords, paragraph 282. 82. In that, what they use, these are all very, real exposition of the constitution by the lordships. When they use this sentence, but I must state, when remarks are made about the governor, kindly look at the sentence where the lordships say,
Yes, sir.
in fact, it would be a case of his reporting against his own government, but this may be a case of wearing two hats. Not when he recommends for wearing two hats, one as the head of the state government and the other as a holder of an independent constitutional office whose duty is to preserve, protect, and defend the constitution. But it is one thing to say the governor is bound to do whatever we say. It another thing to also see that he also holds an independent constitutional office whose most preeminent duty is to protect and defend the constitution.
Yes.
But in Bommai again, because they have relied upon the aid and advice of the Council of Ministers.
That is at 320.
Yeah, 320. But in fact, Article 163, subclause 3, what says as to what was the aid and advice given by the Council of Ministers to the governor will not be called into question in any court. Rather, the court will not inquire into it. That,
Slight dilution later.
that was when it was cited, what their lordships held is, what happens between the president and the Council of Ministers, we are not concerned. Ultimately, what is the decision the president makes is what we will look into it for the purposes of arriving at a decision. That is what I wanted to submit these last four of them. But I will address the last question lordships asked about the role of the chief minister. I'll have to answer that. Before that, two other things, Lord, I must bring to lordships notice. Is one other decision, Lords, of course, not for any other purpose, but the Terrorist and Disruptive Act, TADA, also contains some sort of a filter like this, wherein, Lords, prior concurrence of the authority is required before initiation of investigation. For interpreting those provisions, Lord, in Satyan, one of the lordships may kindly see in that compilation at serial number 7, State of AP versus A. Satyanarayana. That commences at page 181. But I am citing this judgment for this proposition, and I'll bring to lordship's notice as to why this becomes relevant. At page 181, lordships get it, paragraph 8. But there is section 20 capital A of the TADA, which provides for a prior permission. But they go to the extent of saying
approval.
Prior approval. No, their lordships go to the extent of saying in para A, even an oral approval is sufficient. But the emphasis which I am saying is not in, but I was bringing to lordships notice, this is not the first of its kind where prior approval is required. Number of central enactments and some state enactments as well as have this prior approval before investigation is done. Interpreting most of these provisions, their lordships hold, that is, it is not something very formal. It is not something which is elaborate. It is something which has to be more informal, considering the prima facie satisfaction of the authority concerned. In Satyanarayana's case, they go to the extent of saying even a oral permission is also sufficient. But this is one aspect. Then, Lords, I wanted to bring to Lordship's notice about this B.S. Yediyurappa's case they have cited. That is division bench judgment of this court. To say about advice, but I must bring to Lordship's notice that that decision, division bench decision, Lord, in fact, does not state any law, does not make any declaration of any law. And Lord, certainly cannot be considered as a precedent.
Does not declare any law.
It does not. But I'll bring to Lordship's notice why. That is, Lordships have the division bench judgment. Yeah, please.
Yes.
So there, one of the Lords, I had some knowledge of how that matter went.
You had appeared.
No, I had not appeared. Lords, I was there as additional advocate general that time. I had not appeared. In fact, Lords, if I recollect, Mr. Ram Jethmalani had come to argue this case initially, but I think by the time the matter came up for final hearing, he was not there. But there, but apart from other things, the Council of Ministers, my lords, had sent an advice to the governor. But it so happened during the course of the hearing, the governor, forget referring to that advice was also not available in the file. Therefore, their lordship said that advice which the Council of Ministers have supposed to have been given, it is nowhere reflected. Forget considering that. Therefore, we say that that should have been considered. Is all that division bench says. No argument was advanced in the line which has been advanced today before your lordships about either citing Antule or, for that matter, lords, MP State Establishment Act to say that it was. And the governor, lord, there, of course, lord, had granted prosecution. Of course, by the time the matter was heard, the petitioner, lord, had ceased to be the chief minister, etc. That is, therefore, lord, that Yediyurappa's case cannot be cited as a precedent is my submission before your lordships. Then, lords, they have relied upon the standard operating procedure, which they say that
The CBI.
SOP. It is for CBI, and lord, according to me, there is no statutory force to that. There is no statutory force because under the Act, lords, there is no power given to the central government to make any guidelines under 17A. There is no provision. So there cannot be, by way of an executive instructions, add or subtract or dilute the provisions of 17A. Then, lords, the last one lordship said about recommendation. They have said, what is my recommendation? What is my decision has been answered. But may I request lordships to kindly see 17A once again. Of course, my lords, it is very tempting for us to, my lord, bring records before your lordship to say what has been the decision, etc. But these are all matters, my lords, which may require investigation. But on a plain reading of 17A, lordships may kindly discern how it comes. It starts by saying no police officer shall conduct any inquiry or investigation.
No, their
I'll just
their submission is that
relatable.
have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or
But
decision taken
May I
by such
request
public
lordships, may I
servant
request lordships
in discharge of his official functions or duties.
lordships may kindly see, there is the first sentence, lordships may kindly permit me to.
Yes, yes.
No police officer shall conduct any inquiry or investigation into any offense. Lordships may kindly see. Lordships may permit me to emphasize into any offense alleged to have been committed by a public servant
Under this act.
That is a comma. There is a comma there.
Comma.
There is a comma.
Under this act,
That's true.
any offence
Any offense for that.
under the Prevention of Corruption Act.
That's true.
Yes.
But I will just demonstrate before your
Any
lordship.
offence, it can be any offence under the act.
Yes, comma, then it is followed by where the alleged offense is relatable to
Yes,
any recommendation made or decision taken by such public servant
yes.
in the discharge of his official functions or duties without the previous approval. Now, my lords, the Prevention of Corruption Act starts from 7 to section 7 onwards, refers to several of the offences.
Yes.
all the offences there, my lord, do not per se involve a decision or a recommendation of the public servant. For instance, lordships may
No,
kindly.
section 7 is straight away, it is a criminal misconduct by a public servant where he is trapped or accepting money or others.
No, lordships may kindly see
13
section,
is disproportionate.
no, lordships may kindly see section 7C, for instance.
Yes.
If for instance, 7C, lordships may kindly see. Any public servant who,
Induces
for-
another.
no, I am only trying to make this point for you. Let me explain what is that I am trying to say.
So you're trying to bring in the
All offences-
acts that are now foundation for the sanction under 7C.
No, I'm not referring to the present facts of the case. It could possible also, it is possible 7C is also invoked. Maybe. I am at this stage, it may not. All that I am bringing to lordship's notice is if a reading, but a correct reading of 17A is made, it encompasses all offences under the act. Lordships may permit me to state in the same
Yes,
breath.
all offenses under.
Need not, therefore they use the word relatable to the recommendation or the decision. For instance, 7C, for instance, what 7C makes it an offense if a public servant induces another public servant to do an act for the benefit of himself or any other person.
Yes.
There obviously there is no recommend or decision by him. Lordships may keep this proposition in mind. But would that not take away the filter of 17A? No, obvious answer according to me is no, because it speaks of any offense under that. Therefore, not the word relatable to any decision or a recommendation must be meant to mean any of relatable to the offenses, right from 17 to 30. It need not be, put it across simply, it need not be that there must be a decision taken by me or a recommendation made by me, which is culpable of for any of the offences commencing from 7 to 30.
Yes.
It could be in a given situation, it may be perfectly open for anybody to argue that recommendation may include oral recommendation as well. But I'm only bringing to lordship, ultimately, the Honorable Supreme Court as well, this is the Prevention of Corruption Act. The interpretation must be to ensure the laudable objects of the act is fulfilled and not to allow delinquent public servants to get away by such interpretation. My submission before your lordships is that. Therefore, whenever we speak of recommendation or a decision to be made by the public servant concerned, it need not be, I'm not saying that in this case, I'm for a moment not suggesting it need not be a recommendation or a decision per se, but if any of the offences under 7 to 13 are invoked, it would be certainly the protection of 17A will come. Of course, the alternative argument of Mr. Tushar Mehta that if according to them 17A is not applicable, then it also leads to investigation any other way is something which lordships will kindly consider. Therefore, lords, my respectful submission to your lordships is that having regard to these aspects, the writ petition at this stage would not call for any interference. That, my lord, the petitioner, I must bring to lordship's notice, is at a stage where there is a threshold beginning. He would get many more opportunities in case anything adverse is taken by either the magistrate before whom the private complaint may go or before the station house officer if a first information is to be lodged. He would get an opportunity in case an adverse, let us say a first information report is.
So the complaint is already before the sessions court.
It is, complaint is before the sessions court, but no orders are passed. But all that I'm saying is.
That was awaiting approval.
No, all that I'm saying is it is not that they will not have an opportunity. In case an adverse or if something is to be done there, they will certainly have an opportunity to call into question. Therefore, lords, my respectful submission is that this matter does not call for interference. Of course, lords, I must say, I do not want to use the word profound respect, which Mr. Tushar Mehta gave a different meaning, but having regard to the totality of the circumstances, I did not want to repeat myself as to what Mr. Leonard Solicitor General had dealt with.
Yes.
I'm sorry, Lord, if there has been some repetition.
No, that's all right.